your right hand for me, Mr. Verser? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, thank you. You can put your hand down. Mr. Pfeiffer, is there a plea agreement, sir?
There is, Your Honor. The agreement that has been worked out between myself and defense counsel is for the defendant to plead guilty to count 1, domestic violence, third offense. People had a Killebrew agreement to no further upfront jail at time of sentencing. Upon successful plea and sentence, the people agreed to dismiss count 2, interfering in electronic communications. The people also agreed not to pursue witness interference charges for contacts prior to the date of March 22nd, 2023, as they relate to this case.
Okay. Mr. Goodrich, do you and Mr. Verser waive reading of the charge that would be dismissed, that being count 2?
Yes, we do.
Mr. Pfeiffer, will you please read the charge to which you will be pleading?
Yes, Your Honor. In the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on or about 11/9/2022 at 1801 West Shiawassee Street, City of Lansing, Ingham County, the defendant for count 1 domestic violence did make an assault or an assault and battery upon Samantha Silvas, an individual with whom he had a child in common, contrary to MCL 750.812. There could be restitution if this offense resulted in damage to another individual's property or physical injury or death to another individual per MCL 780.811A. This is normally a misdemeanor punishable by up to 93 days and or $500. But under the third offense notice, take notice that the defendant was previously convicted of assaulting or assaulting and battering his or her spouse, former spouse, an individual with whom he or she had a dating relationship, an individual with whom he or she had a child in common, or a resident or former resident of his or her household, or of knowingly assaulting a pregnant individual by violating MCL 750.812 on or about 6/6/2022, and by violating MCL 750.812 on or about 6/6/2022, and therefore upon conviction will be subject to an enhanced sentence under MCL 750.815. This becomes a felony with a maximum punishment of up to 5 years and or $5,000. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. Court shall order law enforcement to collect a DNA identification profiling sample for sentencing a disposition if not taken at arrest. And this is against the peace and dignity of the state of Michigan.
All right, Mr. Pfeiffer, under these circumstances of pleading to the single count, there is not consecutive sentencing. Is that correct?
There is not, Your Honor.
Mr. Verser, it is my understanding you are going to enter a guilty plea to that charge as read by Mr. Pfeiffer. And as he stated, due to the third offense notice, the domestic violence conviction carries with it the potential sentence of up to 5 years incarceration. Do you understand that?
Yes, Your Honor.
And knowing that, how do you wish to plead to this charge?
Guilty, Your Honor.
Are you currently on probation or parole anywhere?
No, Your Honor.
Do you understand that if your plea is accepted by me, you will not have a trial of any kind? So by entering this guilty plea, you are giving up all the rights you would have had at a trial?
Yes, Your Honor.
Can you read and understand English language?
Yes.
Well, let me back up a second. Mr. Goodrich probably didn't need to cover that since I assume you probably don't have a written advice of rights.
Correct. We do not have a written one.
Okay, because of his incarceration.
Yes.
All right, then I'll cover those on the record. Well, let's back up a second then, Mr. Verser. First of all, you indicated you understand that if I accept your guilty plea, you will not have a trial of any kind, and you are giving up all the rights you would have had at a trial, correct?
Correct, Your Honor.
Now, those rights that you would have had at a trial include the right to be tried by a jury, the right to be presumed innocent, the right to, until you are proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear and for you to be able to question those witnesses, the right to have me order witnesses to appear for your defense, the right for you to remain silent at the trial and not have that silence used against you, or alternatively, you could waive your constitutional right to remain silent and you could choose to testify at the trial. Do you understand that you have all those rights?
Yes, Your Honor.
You understand that by pleading guilty this afternoon, you are giving up each and every one of those rights?
Yes, Your Honor.
Also, if your plea is accepted by me, you will be giving up any claim that you entered this plea as a result of a promise or a threat not told to me during this hearing. And you're also giving up any claim that it was not your own choice to enter this guilty plea. Do you understand all that?
Yes, Your Honor.
Further, by pleading guilty, you will not have an automatic right to appeal your conviction or your sentence in this case. If you want our appellate courts to review those things, you have to ask them for permission and see whether in their discretion they would agree to review your case. Do you understand all of that?
Yes, Your Honor.
Further, by pleading guilty, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial. Do you understand that?
Yes, Your Honor.
Do you have any questions, Mr. Verser, about what your rights are or what rights you are giving up by pleading guilty?
I think I'm clear on my rights, Your Honor.
Okay, Mr. Goodrich's plea agreement as stated by Mr. Pfeiffer, a full and complete statement of the plea bargain.
Yes, it is, Your Honor.
Mr. Verser, a moment ago, Mr. Pfeiffer, the assistant prosecuting attorney, stated the plea agreement in this case. Is what he stated the same as your understanding of your plea agreement?
Yes, Your Honor.
Has anyone promised you anything beyond what Mr. Pfeiffer stated in order to get you to plead guilty?
No, Your Honor.
Do you understand that I have not entered into an agreement with anyone as to your plea or what your sentence will be, and I will not determine your sentence until we come back on another date?
Yes, Your Honor.
Do you also understand that I do not have to go along with the sentencing agreement for no upfront jail? But if I choose not to, I will tell you that at the time of sentencing, and I will give you an opportunity to withdraw your plea. Do you understand all of that?
Yes, Your Honor.
Has anyone threatened you in any way to get you to plead guilty?
No, no, Your Honor.
Is it your own choice to plead guilty?
Yes, Your Honor.
Are you pleading guilty because you believe you did in fact commit that crime by doing those things that are stated in that charge? Do you believe you did those things?
Yes, Your Honor.
Okay. Mr. Goodrich, can you help with the factual basis, please?
Thank you, Your Honor. Mr. Verser, on or about November 9th of 2022, were you at 1801 West Shiawassee Street?
Yes, Your Honor. I mean, yes. It's
Okay.
very good.
And is that located in the city of Lansing, County of Ingham, State of Michigan?
Yes.
And while you were at that location, did you get into an argument with Samantha Silvis?
Yes, my wife is.
Okay, and as there states, so have you been in some type of either dating relationship or do you have a child with Miss Silvis?
We're married.
Okay, and you have a child as well?
Yes, we have 2 kids together.
Okay. And over the course of this argument, at some point, did you push or shove Miss Silvis?
Yes, yes.
And did you do that in self-defense?
You remember it long ago, but yes, I think it was kind of sort of in the manner of it. But
Well,
yeah,
well, sir, keep in mind, acting in self-defense is not against the law. So I'm saying at some point, did you shove her out of anger and not done in a way to just protect yourself?
it was probably both.
Okay.
Can you make it that clear enough, or?
Is it fair to say, is it fair to say that you did not need to shove her to defend yourself from being harmed?
Right, that's fair to say.
Okay, Your Honor, I believe we have a factual basis for domestic violence in this matter.
We're going to cover the third offense notice in a second, but Mr. Pfeiffer, as to that part of the promises, threats, or inducements not disclosed on the record?
Not from the people, Your Honor.
No, Your Honor, thank you.
Have I fully complied with MCR 6.302?
You have, Your Honor.
Yes, Your Honor.
And I'm going to accept Mr. Versa's guilty plea. I find it as understanding, voluntary, and accurate. It's factually supported. It's free from any duress or coercion. We are going to set sentencing in this matter for May 24 at 9:15 a.m. in the courtroom, if that works for you, Mr. Goodrich.
Yes, Your Honor.
Mr. Pfeiffer, good with you?
Yes, Your Honor. And if it's not, I will make it good with me.
Okay. We're going to come back, Mr. Versa, on May 24th at 9:15 a.m. here in the courtroom in person for purposes of sentencing. In the interim, you have to be interviewed by the probation department to prepare a pre-sentence interview form or pre-sentence report form. And, I want you to cooperate with that interview. They will contact you if you're still in the jail when they're ready to do the interview. They're going to contact you in the jail. If for some reason you're released between now and when they contact you, it'll be your responsibility to immediately contact the probation department and set up your pre-sentence interview. You understand all of that, Mr. Versa?
Yes, Your Honor.
And
Excuse me, Your Honor.
hold on one
Well-
second. Looks like DNA has already been collected. All right, go ahead, Mr. Goodrich.
Yes, Your Honor, before we conclude today, I would like to address bond in this matter. The
All
plea
right.
agreement applies to the date of sentencing, not before, and I understand that. But we would ask the court to consider granting Mr. Versa a PR bond at this point. He has been incarcerated for approximately 150 days at this point. He's never been out throughout the entirety of this case. There's no longer a risk of him trying to intimidate a victim or anything along those lines into not showing up at trial. He has already admitted his deeds here and has been convicted. I believe Mr. Fight, I just said I obviously wasn't the attorney at the beginning of the case. I believe that there was some issue or allegations regarding phone calls made back in December, but it's my understanding that has not continued in any way, shape, or form in the last several months. So we would ask the court to consider a PR bond at this time, Your Honor. Oh, I just also wanted to point out, I know he's had a lot of Mr. Versa's had a lot of family difficulties. He does need to get a hip replaced, so he's got a medical issue that he wants to get to. His children, one of his children, his 12-year-old, has been going through heart problems where they've been in and out of the hospital a lot. He has another child who's autistic and requires some extra work and extra supervision. So we would, again, and he told me that he would be able to stay with his sister on Burnaway Street if he were able to be released, Your Honor. Thank you.
Mr. Goodrich, in a letter that I received from Ms. Silvas, she indicates that she's requesting, this is dated March 12, 2023, she's requesting that the current personal protection order / no contact order in this case be terminated. Now, I understand the no contact order part of it. Was there or is there a personal protection order?
Your Honor, I believe she's conflating the two. I don't believe there's actually a PPO.
All right. Is that correct, Mr. Pfeiffer, as far as you know?
I am not aware of any personal protection order. It doesn't mean it doesn't exist, just that I don't know about it, but I would like to be heard on this issue.
Sure. Go right ahead.
Your Honor, the defendant did call the victim when this case first started several times. It basically telling her not to come to court. This is a pattern that I was made aware of by the victim and her family in prior cases. The defendant was on probation for the domestic violence charges against this victim when this offense was committed. And then when in January, a bond argument was asked for as well, dropped down to a PR bond in this matter, I informed the court of a litany of calls the defendant had made since the examination to the victim unsuccessfully from jail. And as a result, this court denied that bond motion. Now, from my brief look through the defendant's contacts in the news system, I do not see anything that would indicate he is reaching out to the victim anymore. I do not have anything to show that he's doing that. But to be blunt, Your Honor, I've seen that in many cases before, and then immediately after the plea, they think that everything's fine now and they start talking to him again. And while I appreciate Mr. Goodrich's point that there's no longer a trial that to stop her from going to, the issue is we still have a sentencing hearing. I literally sentenced someone or had a sentencing for someone on, I think it was Tuesday of this week, where he had called the victim after his plea and told him, don't come to the sentencing hearing. That is still an official proceeding where the victim has the right to testify and be heard as to the matter, and therefore attempts to potentially influence them are still a very real concern for my office. As a result, I would ask that you leave the bond where it is between now and the sentencing date because of the prior contacts in the matter, because of the fact that he was on probation for domestic violence at the time he committed this act of domestic violence. And I believe it is appropriate to leave to that point because, to be frank, he could easily contact her between now and sentencing and lose that agreement to no further upfront jail. I fully understand the concerns about the child's medical condition